This topic relates to disputes cognizable by revenue courts under the Punjab Tenancy Act 1887. As the heading of the book shows, the Punjab Tenancy Act, it relates to the rights and liabilities of tenant. So, a tenant is connected with the land, so the law relates to the land. So, in order to appreciate this law, we are to see what the land is. Land has been defined in section 4, subsection 1 of the Punjab Tenancy Act 1887. Land means land which is not occupied as the site of any building in a town and is occupied or has been let for agricultural purposes or purposes subservient to agriculture or for pastures and includes the site of buildings and other structures on such land. So, in easy words, we can say that agricultural land and the land subservient to the agriculture is land. All other chunks of the properties are not included in it. So when we talk of the Punjab Tenancy Act, we have to keep it in mind that we are concerned with the land and not with any other property. So the land is occupied by the owner himself or by the tenant. So when it is occupied by the tenant, then the Punjab Tenancy Act comes into play. So what the tenant is? Section 4, subsection 5 says, tenant means a person who holds land under another person and is or but for a special contract would be liable to pay rent for that land to that person, but it does not include an inferior landowner or a person to whom a holding has been transferred or an estate or holding has been let in form under the Punjab Land Revenue Act 1967 for the recovery of an area of land revenue or of a such areas or a post person who lies from the government a lease of unoccupied land for the purpose of subletting it. So when we decide whether a person is a tenant or not, we are to see whether he is occupying the land, whether he has any contract with the owner, or whether he is an agricultural land occupier, and if he is occupying the land as a tenant, he is bound to pay the rent to the owner or to the landlord. But when we talk of the landlord, we are to see what the landlord is. Landlord under section 4 subsection C has been defined. Landlord means a person under whom a tenant holds land and to whom the tenant is or but for a special contract would be liable to pay rent for that land. So when we find the definition of tenant and landlord, we find that there is a relationship between the two. And when there is a relationship between the two, then the Punjab Tenancy Act comes into play. So when there is a tenant and there is a landlord, how this is created? is a question how the tenancy is created. For this purpose, 1991 1991 SEMR 228. I'm going to read it. Tenancy is not only created by express contract, but also by implication or by conduct of parties. So, this law deals with the creation of tenancy. So, there are three modes of creation of tenancy. Number one, there is a special contract between a tenant and landlord, and that contract creates the tenancy. Then there are circumstances when the tenancy is created by operation of law. When the law provides certain factors which may enable us to find out whether the creation of tenancy exists or not. And the third one is the devolution of the rights. When a tenant dies, his legal heir shall be deemed to be the tenants. And when a landlord dies, his legal heir shall be deemed to be the landlord. So the relationship is created on account of devolution of the rights in the tenancy. So the relationship of landlord and tenant are created. There is another aspect which is to be kept in mind, that is 2001 MLD. It 3012, it draws a distinction between mortgagee and a tenant. It reads as follows: mortgagee had to make payment to mortgager in advance or to be advanced by way of loan, an existing or future debt. Mortgagee was not to pay share to landlord of the crop shown by him. Payment of share of both Batai was the only liability of the tenant. So there is a distinction between a mortgagee and a tenant. Once a tenant is always a tenant. Once a mortgage is always a mortgage. So the liabilities, rights and duties of mortgagee are altogether different from the rights and liabilities of a tenant. A tenant should not be considered as a mortgagee, and a mortgagee should not be considered as a tenant. So the creation of tenancy is the only criteria to determine whether there exists the relationship of landlord and tenant. And if there exists a relationship of landlord and tenant, then of course the Punjab Tenancy Act comes into play. Now there are certain disputes between tenant and landlord. When one person asserts a fact, the other denies thereto, and a material proposition arises therefrom, then there is need of adjudication thereon. Then for the purpose of adjudication, we are to resort to the Punjab Tenancy Act, that how to resolve this controversy between landlord and tenant. For this purpose, Punjab Tenancy Act you may see section 77. Revenue codes and suits cognizable by them. So there are two categories. One is the revenue codes and other is the revenue officers. Now we are now dealing with the question of revenue codes and not of the revenue officers. So this section derives the force which gives powers to the revenue court. And it has been divided in three groups: first group, second group, and third group. Now we take it one by one. If there is a question of enhancement of rent, the landlord claims that the tenant should enhance the rent, but the tenant denies thereto. Or when the tenant says that the rent should be reduced and the landlord denies thereto, then what will happen? Then any party aggrieved or having the cause of action may institute a suit before the revenue court under section 24 of the Punjab Tenancy Act. Sometimes it happens that there is a need of alteration of rate of rent due to alteration in the property. The property has enhanced, the property has reduced, the area wherein the property is situated has become more precious and the rates have changed. So for the purpose of alteration of rent, any party, either landlord or tenant, may resort to the revenue court for the purpose of alteration of the rent in accordance with the new requirements. So the revenue court shall adjudicate upon the matter on the basis of the pleadings of the parties. How a party is claiming alteration and why he is claiming alteration and what are the circumstances wherein the alteration is required. So all these facts at issue regarding the alteration of rent are to be adjudicated upon by the revenue court. There are certain examples when the tenancy is on the basis of a contract, and when the contract provides certain period of tenancy, then after the expiry of that period, the tenancy should be terminated. But the law says that once a tenant is always a tenant. So the agreement which provides a limit of time for the tenancy, it may be extended. So the law says that this time is voidable at the option of landlord or at the option of tenant. So if any party wants to enhance the time, on the termination of the time, he may file a suit before the revenue court for the purpose of determining as to for how long this tenancy should continue. So these are the circumstances that a suit is to be instituted for the purpose of determining. Now there are certain factors regarding the occupancy of the tenancy. When this question arises, again it shall be the subject matter of the suit before the revenue court. So the revenue courts are to determine the question of occupancy. So revenue court has got the jurisdiction. Now we come to the second group. There are certain conditions in the contract, but a tenant is not ready and willing to perform his part of the contract. So the Tenancy Act provides the grounds whereupon a tenant may be ejected. So how a tenant is to be ejected? There should be a suit by landlord to eject a tenant. So when the landlord finds that there exists a ground for the ejectment of a tenant, he may file a suit for ejectment of tenant. The section relevant for the purpose is 45 of the Tenancy Act. Now we come to another question that relates to the recovery of possession or occupancy or for compensation or both. It is the second group, part G. I again read it. Suits by a tenant under section 50 for recovery of possession or occupancy or for compensation or for both. For this purpose, there is an authoritative pronouncement 2002 CLC 1082. Plaintiff's claim was that defendants, without having lawful authority, had been dispossessed from suit land. Procedure for restoration of possession has been provided under Punjab Tenancy Act 1887. Tenant could file suit under Section 50 of Punjab Tenancy Act in Revenue Court as contemplated in Section 77, Group 2. No other court could take cognizance. Now, here is an important point which requires further elaboration. Section 9 of Specific Relief Act provides that whenever any person is dispossessed from the property within 6 months, he may institute a suit for the restitution of the property. So a suit under Section 9 is competent when a person who was in juridical possession of the property has been illegally dispossessed. But this section 77 of the Punjab Tenancy Act says that if a tenant is ejected without resorting to the lawful measure, then he may file a suit for restoration of possession. Now, Section 9 and Section 77, we have to draw a distinction between the two. When there is a relationship between landlord and tenant, between the parties, then if a tenant is ejected otherwise than in due course of law, he should not go under Section 9, but he should institute a suit under Section 77 of the Punjab Tenancy Act. Now, when we invoke the provision of Section 77 of the Punjab Tenancy Act 1887, we are to file a suit not before the civil court, but before the revenue court. So when a tenant wants restoration of possession, he does not go to the civil court. He needs not go to the civil court. There is no need for him because the jurisdiction of the civil court is barred under Section 77. And the Section 77 provides that when there is an ejectment of a tenant, otherwise than be in due course of law, he may file a suit for the restitution and the restoration of possession under Section 77. So Section 77 is in fact a bar on the proceeding before the civil court. So it should be kept in mind that if you are going for the restoration of possession of a tenant who has been dispossessed by the landlord, otherwise than in due course of law, then we should resort to the revenue court and not to the civil court. Now the next is regarding the transfer made of a right of occupancy. This suit is also filed in the revenue court. Now this next one is very important. Any other suit between landlord and tenant arising out of the lease or conditions on which a tenancy is held. This is an important provision of law. When there is a lease, the lease may be in writing, the lease may be by operation of law, the lease may be on account of devolution of inheritance, whatsoever the nature of the lease may be. A tenant or landlord, if want to resort to the court for the implementation of the terms and conditions of the lease, and when there is a dispute regarding rights and liabilities under the lease, so the suit is to be filed on the basis of a lease, not before the civil court, but before the revenue court. I again read it. Any suit, any other suit between landlord and tenant arising out of the lease or conditions on which the tenancy is held is to be filed before the revenue court, and the civil court shall have got no jurisdiction. Sometimes the question of payment is involved. Then if there is overpayment, even then the revenue court has a jurisdiction. Then there is a third group. When there is a matter relating to the areas of rent, then he needs to file a suit before the revenue court. So these are the grounds and the causes of action which give rise to a suit before the revenue court, and the civil court shall have got no jurisdiction. Now there are certain authorities. I give you an example. A tenant is in possession of the property, and the landlord is threatening him to take away the possession forcibly. Then ordinarily a suit for perpetual injunction is competent. Perpetual injunction can only be granted by the decree made at the hearing and upon merits of the case, and the defendant is thereby perpetually enjoined from the assertion of his right or from the commission of an act which is contrary to the rights of the plaintiff. So in this situation, a suit for perpetual injunction should be competent. Once it happened that a tenant filed a suit for perpetual injunction before the civil court, the matter went up to the Supreme Court. Then the Supreme Court held that the civil suit of perpetual injunction is barred under Section 77 of the Punjab Tenancy Act, because the matter relates to the lease between the landlord and tenant, and the tenant is possessing the property under a lease. So if there is any threat or invasion on the right of a tenant, he should go to the revenue court and seek the redressal in the form of perpetual injunction. So in this situation, a suit for perpetual injunction by the tenant against the landlord shall be competent before the revenue court, and the civil court shall have got no jurisdiction. So these are the authorities on the point. एक आखिरी फिक्र मैं ऐड कर रहा हूँ. So the matter is very simple. When there is a dispute regarding the issues which are mentioned in Section 77 of the Punjab Tenancy Act, and a party wants relief under those provisions, then the civil court shall have got the jurisdiction, and it is only the revenue court which shall decide and adjudicate upon the matter. So we are to draw a distinction between the revenue court and the revenue officer. So these questions which we have discussed today relate to the suits triable by the revenue court and not by the revenue officers. Thank you for today.